We've already talked about how every notary act must be recorded in the journal, and you'll remember that willful failure to properly maintain the journal, that is, to not enter information in the journal respecting your notary services, is a misdemeanor offense. This journal is a record of important information and can be used as evidence in court, so you'll need to keep it safe, secured, and completed at all times. But exactly how do we fill out journal entries? Let's take a close look at a journal. Not all notary journals are the same, but all notary journals should have the required information present. Journals, of course, differ in their design and by the type of optional information that they might have included. But remember that most notary journals are designed as journals for notaries in all of the states and not just California. So while some practices may be valid in other states, you need to know what's acceptable for the state of California. So California requires certain specific information included in the notary journal. The information that must be included are as follows: the date and time the notary public performed the notarial services. Now you can write the time in regular standard time, but if you do, be sure to circle AM or PM or indicate AM or PM or military format. But the law does require the time of the act to be recorded. The date alone is not enough. You'll need to include the type of notarial act performed. Well, we haven't really yet introduced the notary acts, but by now you should recognize the term acknowledgement as a notary act. Other notary acts we'll discuss that could be included here would be proof of execution by a subscribing witness and a jurat. Should any member of the public request a photocopy of the journal entry, you'll remember we talked about that, that notary act should be recorded. Also, if copies of specific journal entries should be requested by the California Secretary of State or through civil or criminal subpoenas or by a peace officer investigating a crime, be sure to record it in your journal. Now, the Secretary of State suggests that you do not use abbreviations for notary acts in order to avoid confusion. This particular journal has already been printed with the abbreviation ACK for acknowledgement. However, the front of the journal designates the pre-printed abbreviation, so that each and every time it's printed there's absolutely no way to misinterpret what that means. If you're using a journal that doesn't have such a convention, be sure to write out the word rather than abbreviate. Most notaries, for example, will use a single letter, A, for acknowledgement. Clearly, that is not the best practice for your notary journals. Even though this journal adopts a specific convention, the best practice would be to write out the word acknowledgement in the space below. If you're recording information on a jurat, write the word jurat rather than the abbreviation. You must note the title or the character of every instrument sworn, affirmed, acknowledged, or approved before the notary public. The character of every instrument means the kind or type of document on which the signature is being notarized. Most notary acts relate to another person signing or certifying a document. A description of the document containing the notarial act must be recorded in the journal in addition to the type of notary act being performed. The title or description of the document, especially if the document is in a language that you cannot read, would be entered in the section noted for that purpose. For example, the signatures on grant deeds are typically acknowledged. The journal entry for a grant deed will describe the character of the instrument as a grant deed, and the type of notarial act performed as an acknowledgement. Another example would be if there's no title on a document and the document is a sworn statement or affidavit. The notary may record that information in the journal as a declaration or sworn statement. If more than one document contains notarized signatures, the notary public must record the title or character of each document. A separate line must be used for each document. For example, a set of loan documents should never be simply described as loan documents without listing the title of each document that requires the signature to be notarized, because what we'll find out is that there must be a signature for each document that was notarized. And every notarial act must be entered separately as a unique journal entry. I just mentioned you're going to need the signature of each person whose signature is being notarized. There'll be a statement as to whether the identity of the person was based on satisfactory evidence. And if the notary accepted an identification document, such as a driver's license, a passport, and so on, then the notary public must record the type of identification document, the governmental agency that issued the identification, the serial or identifying number on the identification document, and the date the identification document was issued or expires. Remember, you can use an expired identification document as long as it was issued not more than 5 years previously. If the satisfactory evidence is based on the oath or affirmation of a single credible witness, then the journal must contain the signature of the credible witness or the type of identification document presented by the credible witness, the governmental agency that issued the identification, the serial number or identifying number on the identification document, and the date the identification document was issued or expires. Let me reiterate that. When you use a single credible witness, the credible witness must either sign the journal or the notary public must enter the identification documentation into the journal from that credible witness. Now, of course, the best practice is to obtain both the signature and the identification documentation in your journal if you're using a single credible witness. Okay, if the satisfactory evidence is based on the oath or affirmation of 2 credible witnesses, then the journal must contain the signatures of each of the credible witnesses and the type of identifying documents presented by each of the credible witnesses, and the governmental agency that issued each identification document, the serial numbers or other number on each of the identification documents, and the date of issue or expiration of each identification document. Now you'll need to note the fee that you charged for the notarial act. You're not required to charge a fee for notarial acts, but if you do charge a fee, then you need to indicate what fee you charged. If you didn't charge a fee, then put the number 0, and that indicates no fee was charged, but you must include an entry there. Now, if there are additional charges for travel or for other services, those charges can be itemized in the additional information or comments column, so you can distinguish those types of fees from the notarial act fees. Okay, if the document's a deed, a quitclaim deed, a deed of trust, or other document affecting real property, or a power of attorney, the notary public must require a right thumbprint in the journal as part of the line item entry. If the right thumbprint isn't available, then the notary public must have the party use his or her left thumbprint or any finger available, and the notary needs to record the left thumbprint or whatever other fingerprint was captured in the journal and indicate why a right thumbprint could not be used. If the party signing the document is physically unable to provide a thumbprint or a fingerprint, the notary public must record that fact in the journal and must provide an explanation of the physical condition of that person. By the way, these are some notable exceptions of documents that do not require a right thumbprint that you should know about. A thumbprint is not required for a trustee's deed, for a decree of foreclosure, or a non-judicial foreclosure, or a deed of reconveyance. The only thing you can do is just remember those for the exam, because frankly, we're going to get a thumbprint for every signature anyway. Notary law doesn't prevent it, and we really like this practice.